All right, are you Renisha Pyan? And Ms. Pyan was previously in court, entered a plea of guilty to the third-degree felony. Shh, y'all. Good grief.
Listen.
Take a breath. All right. Ms. Pyan was previously in court, entered a plea of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's in cause number 24-2107. There was no agreement. I have received the pre-sentence report and reviewed it. Is there? Has everyone had an opportunity to do that?
State has you.
And it looks like there were also some letters that I reviewed that were attached to that. And has everyone had an opportunity to review those?
Yes, Judge.
In addition, Mr. Coleman has also filed a state sentencing memorandum, and I've reviewed that as well. Mr. Kimler, have you had an opportunity to review that? All right, this was open to the court. Mr. Kimler, you may proceed.
Yeah, as far as the pre-sentence report itself, there's one thing in here I wanted to address at the outset. It's the allegation she has some type of gang affiliation. I noted that that was first mentioned in the assessment, that there was some type of report, a post-investigation.
I can't hear you.
I'm sorry, there was some, and I'm looking at the gang affiliation portion of it, that there was some type of post-investigation report dated May 4th of 2010 that the pre-sentence investigating officer reviewed. And it said that report, which is not included in the PSI, revealed records that linked her to the 5 Deuce Hoover Crips, which I have no idea what that's about. I've known Ms. Payne, our representative, going on probably 15 years now, and I've never known her to have any type of gang affiliation. I don't know what that report is, and evidently it contains hearsay within hearsay. But then that in itself is not so much of a concern, but the reporting officer then goes on to include in the recommendation portions an assertion that her history includes gang affiliation, which I would take issue with. First of all, I don't even know what they're referencing.
That's fine.
I've never known her to have any type of gang affiliation.
Okay.
So, what that leaves us with then is an unfortunate incident where Ms. Payne possibly could have been charged with something more serious if something had gone awry. Mr. Coleman will address that as far as a shooting, an altercation where a gun was displayed and discharged by her passenger. And while Ms. Payne is not charged with anything in relation to the discharge of the firearm or the altercation, she was in the midst of that situation. And in that context, evaded the police, evaded the law enforcement. I think the court could reasonably infer from the factually uncontested facts in the PSI that she was in a highly emotive state during this incident, where the vehicle in which she was riding or which she was driving had been under assault by people around the shooting, which is probably understandable. And again, she had injected herself into that situation, but she was in an agitated state of mind when she was driving away under the, I guess, the flight instincts with imminent fear that she was operating in that type of mental state. The police officer observes that she did go through a couple of stop signs while he was behind her, but then that she came to a stop. So this wasn't a situation where there was some sort of extended high-speed chase where spike strips were deployed or the vehicle crashed or something like that. I suppose, and again, not to speak on Ms. Payne's behalf, but once she was able to put some physical distance between her and the situation, and she calmed down somewhat, that the rational portion of her brain reasserted itself, and she knew that she was being pursued by law enforcement, so she came to a stop with that incident. She regrets this incident. It's been looking at her criminal history. I know she does have criminal history, including prior probation revocations for felonies. But even at the misdemeanor level, I think it goes back 12 and a half years before she, that she's had problems. So there's been at least a 10-year period here where she's maintained a law-abiding lifestyle. And but for this poor decision to inject herself into this situation with one of her friends, she wouldn't be standing before the court. She has a GED, she has employment history. I think she regrets what happened. And even though I know Mr. Coleman probably is going to reiterate to the court that she's had past prior probation failures, those were a time when she was younger and less mature. I think that with this opportunity, should the court give it to her to complete this probation, she would not let the court down.
Thank you, Mr. Kimler.
And then
Mr.
she would address the court if you want to tell the judge anything.
Everything that he's been is totally true, from my past and everything. And if you guys give me a chance, I won't let you guys down.
Speak up.
I said, if you guys give me a chance, if you give me a chance, he's list, I won't let you down. I won't let myself down.
Thank you. Mr. Coleman?
Your Honor, the court's indicated that you read the sentencing memorandum. I don't have anything to add other than just briefly for the reasons stated in that sentencing memorandum, including the defendant's criminal history, the 3 previous probation revocations, and the underlying circumstances. We don't think the probation is appropriate, and we'd ask for prison sentence. The last time she went to jail, it was for a 2 year state deal. We'd ask for a PCC in excess of more than the. Thank you, Judge.
So she went for 10 months.
I also saw
Is there
a 2
something else?
year state jail sentence on 2011 possession of controlled substance. That's what my notes show. I don't know what the TSI.
Oh, I see that one. Then it was, well, it looks like she was shocked out. And then that didn't
Oh, I
work.
see.
Yeah, okay. I see what you're saying. Why don't you work?
Right now, I'm not working because I had health issues, but I got a job on July the 2nd when I left the court for remodeling homes. But right now, I wasn't able to work because I had doctor's appointments and stuff like that to get my stomach checked out, to see a specialist on it.
Who's your doctor?
My Gulf Coast, Ms. Jordan, Dr. Jordan. That's in Florida.
What about the person that was in the car that claimed, was it Banks, that claimed the purse that had the gun in it?
Yes, that's my understanding, Judge. Was it the passenger?
And was she charged, or he?
I don't know the answer to that.
What's your relationship to that person that was in the car?
That was just a friend.
Female?
A female. But she did get charged.
She did?
Yes, ma'am. She's on probation as well.
She is.
Yes, ma'am.
Okay, so Ms. Pyan, Mr. Coleman makes a good point. You have criminal history. It's kind of similar to one we just talked about, but it's all old and you've been doing so well for so long, but this was a scary situation that could have been ridiculous. I mean, people could be in here, it's the same thing. I feel like I'm a broken record. I mean, people don't just argue and fight anymore. Somebody always starts shooting every single time. So I wouldn't put myself in that position. All right, what I'm going to do, Ms. Pyan, is find that you entered your plea of guilty freely and voluntarily. Find that you are mentally competent, understood the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time I am going to find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you to 10 years in prison, but I'm going to probate that. You're going to be on probation for 10 years. I'm ordering you to pay a $1,000 fine and to follow all of the rules and conditions of probation. This opportunity is giving you the opportunity to serve the time that I just gave you while you're out on probation. So if you do everything you're supposed to while you're on probation, you'll be able to, for all practical purposes, your case in court's over, you'll serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, I just gave you a 10-year sentence, which is probably more than Mr. Coleman was asking for today, and probably more than I would have given you if I'd sent you to prison today. So you're getting an opportunity, but the downside of it is if you violate it, things can be a whole lot worse than they could have been today. Does that make sense? So don't make me regret this. If you do everything you're supposed to on this probation, you can even get off early. But that takes you doing things very differently than you have done in the past. So you know what probation's about, you know what to do to get off of it, you know what to do to end up getting in trouble. I'm going to hand you the trial court certification. This was not an agreement. You have some rights to appeal. You can talk to Mr. Kimler about that. Also, I'm handing you the trial court written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. You need to have a seat here in the courtroom. Probation is going to call you up when she's ready to go over your paperwork.
Okay.
Good luck to you, ma'am. Mr. Kimler, you have